All right, are you Johnny Wright there at the jail?
Yes, Your Honor.
Johnny Wright Jr.? All right, this is case number 18 CR 110, State of Ohio versus Johnny Wright Jr. Mr. Wright's appearing from the jail. This is a hearing being conducted by Zoom on probation violation. His attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. Mr. Kirk, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, Your Honor.
And that's all right with you, Mr. Wright?
Yes, sir.
All right, Mr. Wright was originally put on community control on October the 2nd, 2019 for the offense of possession of heroin, a fifth-degree felony. That was extended on June 23rd, 2020. There was a notification filed on October the 18th by Officer Balser of the Probation Department that indicated that the defendant had failed to comply with various rules, including Rule 2, that he had failed to report since November 17, 2020. Rule 7, on or about 10/18/23, consumed methamphetamine, amphetamines, fentanyl, and THC after being given a drug screen at the jail. Rule 15, he failed to pay court-imposed financial sanctions for court costs. And then on the June 23, 2020 entry, failed to complete residential to show that you had failed to comply. You have a right to cross-examine those witnesses to try to bring out evidence in your favor. You have a right to present evidence on your own behalf, although you're not required to do so, and if you don't, it won't be held against you. If you're found to have violated these conditions, whether you admit to it or if there's a hearing, I can do one of three things. I can continue community control under the same conditions previously ordered, continue it with additional conditions I think that are appropriate, or the third and the most serious is that I could sentence you to a term of incarceration between 6 and 12 months and fine you $2,500. Now, Mr. Wright, do you understand the allegations against you?
Yes, Your Honor.
Do you understand your rights to a hearing?
Yes, Your Honor.
And you understand what the potential consequences if you admit to these violations?
Yes, Your Honor.
And has anyone promised you anything or threatened you in any way to make you give an admission to these allegations?
No, Your Honor.
All right. All right, then do you admit or deny the allegations in the notification that was filed on the 18th of October?
Can I plead no contest?
No, you can either admit or deny. You've already been found guilty. This is just whether or not you complied or not.
Yeah, I'm guilty.
All right, you're admitting?
Yes, sir.
All right. All right, anything from the state probation department regarding disposition?
Yes, Your Honor. The state and the probation department would ask that the defendant be sentenced to a term of incarceration. A couple of things to point out here. It's been nearly 3 years since the defendant was reported to the probation department. He's obviously continuing to use illegal drugs. That in jail back on the 18th. Would also note that this is the defendant's second community control violation. He was originally placed in drug court back in October of 19, violated the conditions of community control in June of 20. At that point, he was terminated from drug court, but he was continued on community control. So based on all that, based upon the multiple opportunities the defendant has had here, his position in the state and probation department is no longer being much community control. That's all, Your Honor. Thank you.
Kirk?
I met with my client on Tuesday, went over the case with him, and at that time he indicated that he was willing to accept whatever term of incarceration or punishment that the court would issue. So we just asked the court to issue sentence.
Mr. Wright, anything you'd like to have you would like to say?
I'm done. I'm done with all the dumb stuff. I'm too old. I gotta get this taken care of. I got grandkids and kids out there I gotta string. I apologize. I'm sorry I let you down. I did that star for you and I graduated.
No, you didn't follow through, obviously, because you're still using drugs, and you say you got to get yourself straightened out, but when you came in and you got arrested, you're still doing drugs. So obviously you're not, you don't seem to want to do that at this point. Well, Mr. Wright, under a new program we're participating in, any sentence that the court imposes would have to be served in a county jail. That probably is what I ought to do, because I don't see you doing much to change your life on your own. But given the situation, I'm going to continue your community control with the condition that you complete the STAR relapse program, and that you and you complete any recommended aftercare, and that you'll remain in jail until you go to STAR, which is on November the 1st. There's a bed date, and you pay the court cost. And I'm going to make a note here, this is your last chance. If you come back in on another violation, you'll just serve the balance of your time. And you'll get the full, don't interrupt me. You'll get the full 12 months, less any time you have credited against that 12 months. So this is your last chance, so you better take advantage of it.
Thank you, Your Honor.
All right, is there anything further from counsel?
No, Your Honor.
All right, thank you. All right, David Howland is next. Are you David Howland appearing there from the jail?
Yes, sir.
All right, this is case number, two cases here. Case number 21 CR 168 and 21 CR 172. This hearing is being conducted by Zoom. Mr. Howland is appearing from the jail. Mr. Jeff Blosser is his attorney, is appearing from his office. Representing the state is Assistant Prosecutor King. In case number 168, the defendant is charged with engaging in a pattern of corrupt activity. No, I'm sorry. In 168, he's charged with aggravated possession of a fentanyl-related compound. In 172, he is charged with several co-defendants with engaging in a pattern of corrupt activity, a second-degree felony. And then that's in count 1, and then counts 20 to 30. He is charged with various trafficking and possession of drugs, methamphetamine and fentanyl. Looks like those are all 4th and 5th degree felonies. And then he's also charged in count 36 and 37 with trafficking and possession of heroin, second degree felonies. All right. Now, this matter was set for a plea, and I have been given a plea form in case number 23 CR 172. Now, Mr. Blosser, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance before the court?
Absolutely, Your Honor.
And are you all right with that, Mr. Howland?
Yes, sir.
All right, since you're not seated in court next to your attorney, in the event that you need to talk with him, you can just let me know, and the court will put you and him into what's called a breakout room, where it'll just be the two of you on the screen talking. The deputy will step out of the room, so your conversation with him can be confidential. So if you need to do that, just let me know, okay?
Yes, sir.
All right. Now, Mr. Howland, I have a plea form in case number 23-172, and I'm going to hold up the first page to the camera to see, show you that it shows that that's a plea of guilty form, has your name, case number on it, and you recognize that form?
Yes, I do.
All right, and then on page 4, there's a sentence right at the top of the page. It says, I enter this plea voluntarily, and immediately below that appears to be Charles Howland over a line that has signature defendant printed under it. I'm going to hold that up to the camera as well. And is that your signature there that showing you?
Yes, it is, Your Honor.
And when did you sign this document, Mr. Howland?
It was last Sunday.
All right. And when you signed it, before you signed it, did your attorney go over it with you and explain everything to you and answer any questions that you had?
Most definitely did, sir.
And you understood when you signed it that it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And Do you feel that you had enough time to fully consider that matter before signing this agreement?
Yes, sir.
Do you feel you were rushed into doing this?
No, sir.
And is this still your decision to go forward with this plea agreement today?
Yes, I did.
And you're doing that voluntarily,
Voluntarily.
all right? So the agreement states on page 1 that you're going to plead guilty to counts 1 and 36. Count 1 is engaging in a pattern of corrupt activity under section 2923.32A1 of the revised code, a second-degree felony. Count 36 is trafficking in heroin under 2925.03A2, a second-degree felony. Now, it further states on page 1 that you understand that the possible sentence for each of those offenses could be a sentence of 2 years to 8 years on each charge as ordered by the judge as a minimum. And that is a mandatory sentence. No, it's not, is it? Count 36 is, but count 1 is not. So there's a presumption in count 1 of prison term should be imposed, but on count 36 it's mandatory. That means you have to be sentenced to a term of at least 2 years and up to 8 years by the judge. And then on count 1 it'd be optional, and that would not be mandatory. Now, under the law, the sentences imposed by the judge is the minimum because for offenses of this nature, the sentencing law provides that a sentence for these offenses could be extended by the Department of Corrections, Rehabilitation Corrections at their option for up to 50%. So what that means is that on count 1, the sentence could be 8 years, and count 36, 8 years. One of those sentences, not both, but one of them would be extended, being extended by 50%. And since 8 is the maximum, that means additional 4 years. So on one count, it could be 8 to 12 years, and on the other count, it would be 8 years, and I'm talking about the maximum, which means a total of 16 years to 20 years could be the potential sentence. Now, there could also be, and the minimum could be 2 years. So, and if the minimum was imposed of 2 years, then it could be extended by 1 year, so that'd be 3 years. So that's how that works. And there's a possible fine of $15,000 in each count. Count 36 is a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years is shown on the form. Now, you understand that, Mr. Howland?
Yes, I do, Your Honor.
All right, and under the law, as I just explained, the court could sentence you to consecutive sentences if you're convicted of both of these offenses. You understand that?
Yes, Your Honor.
Now, Mr. Howland, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control from any jurisdiction?
Yes, sir.
And what is that?
Community control, County.
Your Honor, he's on post-release control.
Oh, post-release control. Okay. Do we have a notification? Pardon me?
Final stamp September 20th, Your Honor.
September 20th. All right, I have that. All right, according to this, then, and thank you for saying that, Mr. Howland, you are on community or post-release control for felonies previously out of this court in case number 17 CR 23, and as of 9/20/23, there were 870 days remaining on that. As of 9/19, there was 870 days, and since then we've had 11 days in September and today is 26th, 37 days in October. So that means there's a balance of 833 days. So under the law, if you're convicted of these offenses, the court can sentence you for committing the offenses while under PRC in your other case to, under the law, to either 1 year, whatever time's left on the PRC, whichever is greater. In this case, 833 days is greater than 365, which is a year. So that means that in addition, whatever sentence can be imposed for these two offenses, the court can impose an additional 833 days to run consecutively to the sentence for the offenses in this case. You understand that? Okay. All right, now, under the law, in this case, each of these offenses carries a mandatory time of post-release control. So once you've finished your sentence, and any extension of up to 50% on one of those counts that the DRC may impose, you will be put under post-release control as you are now for a minimum of 18 months, and it could be up to 3 years. And in the event that you fail to comply with those conditions of that release or supervision, then the adult parole authority could return you to prison for a period of up to 9 months for any one violation, with a maximum of half of the prison term for all violations. But if you commit a new felony, then in addition, whatever sentence can be imposed for that new offense, that court could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time would be left on that period of post-release control, whichever is greater. And as I've indicated to you already, that would have to be served consecutively to the sentence in that new offense. Do you understand that? The charge alleges in this case that in count 1, that on or about the period of November 1, 2022 and continuing through May 1, 2023 in this county, and as a continuing course of criminal conduct in Fayette County, that Carl Walter Lockhart, Evan Scott Clay, you, April Lynn Koch, and other unindicted co-conspirators did recklessly, while being employed by or associated with, directly or indirectly, can conduct or participate in the affairs of an enterprise through a pattern of corrupt activity, and at least one of the incidents of corrupt activity is a felony of the 4th or 5th degree, in violation of Section 2923.32A1 of the Ohio Revised Code. So that's the charge of engaging in a pattern of corrupt activity, with the potential sentence of 2 to 8 years as a minimum, mandatory minimum set by the judge, with possible extension up to 50% or 4 years, plus the fine of $20,000, or I'm sorry, $15,000. Now, count 36 alleges that on or about March 10, 2023 in Highland County, Ohio, and as a continuing course of criminal conduct in Fayette County, Ohio, you and Carl Walter Lockhart did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute heroin, a Schedule I controlled substance, an amount equal to or exceeding 10 grams, but less than 50 grams, when Charles David Hallen and Carl Walter Lockhart knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by the offender or another person, in violation of Section 2925.03A2. So that's the charge of aggravated trafficking, trafficking in heroin, a secondary felony, with the same penalties in count 1, except there is also a mandatory fine of $7,500 and a possible license suspension of 6 months to 5 years. And again, any sentence that would be imposed by the judge would be mandatory. Now, Mr. Hallen, do you understand what it is that you are alleged to have done in each of those counts, and what the state said you did, when, where, and how they allege you did it? And have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, and possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Now, on page 2, there are several sentences printed in bold and underlined, and I'll read those as follows. Defendant shall enter plea of guilty to count 1 and count 36. State will dismiss remaining counts State defense jointly recommend 4 years incarceration on count 1, consecutive 4 years mandatory incarceration on count 36. Defendant agrees to cooperate fully with the task force and cooperate fully against co-defendants. Defendant agrees to repay by money to the task force in the amount of $360. State will dismiss case number 23, Sarah 168, which is, I believe, possession charge. Now, has anyone promised you anything other than that to get you to plead guilty here today, Mr. Howard? And again, well, it's not stated in here, in addition to the 4 years mandatory on count 36 and 4 years on count 1. And count 1 is not mandatory, right, Mr. King?
That's correct, Your
Yeah,
Honor.
okay. The court then, if you are convicted, will in all likelihood also sentence you to the additional 833 days remaining on your PRC, since you would have committed these offenses while under post-release control in your previous case. You understand that? Now, in regard to the recommendation of the amount of sentence, the sentence is a possible 2 to 8 years as opposed by the judge on each count. The recommendation here is 4 on each count. Under the law, that sentence is up to the judge. And so in the event that you plead guilty, I'm not required to follow that recommendation. I could impose any sentence between 2 and 8 years at each count consecutive. So it could be anywhere from 2 years to 20 years total. You understand that?
Yes, sir.
All right. Mr. Howland, do you hold any license or certification from any state governmental agency that regulates any occupation or profession? All right, now you have certain rights you must understand before I can accept a plea. First, you have a right to counsel. Mr. Blosser is appointed to represent you. Now, his appointment isn't simply to see if the case can be worked out, but to defend you and provide any defense that might be available to you under the law that you would like him to provide. So if you decide you do not want to plead guilty, that you want to defend against these charges, he'll continue to represent you and defend you, including a trial, if that's what you want. Do you understand that? Now, under the Constitution and the laws of this state, you have a right to have a jury trial on these charges, Mr. Howland, in which 12 people would be selected from a group of citizens that reside in Highland County that are summoned for jury duty on your trial date. After 12 of those people are selected, the evidence is presented, the judge instructs them on the law, and then that jury decides by unanimous verdict, meaning all 12 would have to agree on each charge as to whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. In that case, you would have what's called a court or bench trial, which means instead of the jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir, I do.
All right, now under the Constitution, Mr. Howland, you have a right to confront witnesses against you and to cross-examine them through your attorney in open court. So what that means is that the witnesses against you have to come into court, testify in open court in front of you and your attorney, and anyone else may be present. After to come into court to testify on your behalf, just like the state. So what that means is if you have witnesses you're not certain are going to come in voluntarily, to request, the court issues a subpoena, which is a court order, that forces them to come to court to be available to testify if you want them to, even though they don't want to be here. Which is the same way the state's witnesses, of course, come in and testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Howland, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this case at any time, including trial. No one can ever make you testify. It's up to you. The state will be required to present evidence that proves to the jury or the court, depending upon which type of trial you've elected to have, of your guilt by proof beyond a reasonable doubt on every essential element of each offense, which is the highest burden of proof that is known under the law. Do you understand that?
Yes, I do.
All right, now originally you entered a plea of not guilty, Mr. Howland. Not guilty plea denied the allegations in the indictment, denied you committed a crime, and it exercised or invoked all the rights that I've just described for you. Now, you change your plea from not guilty to guilty on these two charges. That's the opposite of the not guilty plea. The guilty plea would admit the allegations in the counts 1 and 36, admit that they're true and that they are a crime and you committed those crimes. And that plea waives, gives up all the rights I've described for you this morning, except the right to have an attorney, which you always have no matter what your plea, but with that exception. Your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront the witnesses against you and cross-examine through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It would waive or give up You're privileged against self-incrimination because you'd be saying you're guilty, and that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, which is likely to happen since these are count 2 or 36 is mandatory. And it waives or gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence or under other certain limited circumstances, an appeal could be filed. That would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Howland?
Yes, sir.
Now, do you have any questions about this charge or the possible penalty in either case? Count.
No, I do not.
You understand them?
Yes, sir.
You have any questions about the plea agreement?
Yes, sir.
You understand it?
I do, Your Honor.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand that?
I do.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Where of it, sir?
All right, now, I didn't tell you this at the beginning of the hearing, but if you need to talk to Mr. Blosser before we go any further, I can put you and him into a breakout room where it'll be just the two of you on the screen, and the deputy would step out of the room during that period so you can talk with him privately. So do you have anything you would like to speak to Mr. Blosser about at this time?
No, Your Honor, me and him has talked 2 different times, and he's very informative.
Okay. You have any questions about anything that I've explained here today?
No, I do not, sir.
Then, Mr. Howland, is it your decision to go forward and plead guilty to counts 1 and 36 of the indictment pursuant to the plea agreement that we have just gone over? Okay, then as to count 1 in case number 23 CR 172, which reads that on or about the period of November 1, 2022, continuing through May 1, 2023 in Highland County, Ohio, and as a continuing course of criminal conduct in Fayette County, Ohio, Carl Walker Lockhart, Evan Scott Clay, you, April Lynn Koch, and other unindicted co-conspirators did recklessly, while being employed by or associated with, directly or indirectly, conduct or participate in the affairs of an enterprise through a pattern of corrupt activity. At least one of the incidents of corrupt activity was a felony of the 4th or 5th degree in violation of Section 2923.32A1 of the Ohio Revised Code. The charge of engaging in a pattern of corrupt activity, a 2nd degree felony, carrying a possible prison term between 2 and 8 years, is ordered by the judge with an extension possible of up to 50%, a fine of $15,000. How do you plead?
Guilty.
As to count 36, which alleges that on or about March 10, 2023 in Highland County, Ohio, and as a continuing course of criminal conduct in Fayette County, Ohio, you and Carl Walter Lockhart did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution or distribute heroin, a Schedule I controlled substance amount equal to or exceeding 10 grams but less than 50 grams, when you and Mr. Lockhart knew or had reasonable cause to believe that it was intended for sale or resale by you or another person, in violation of Section 2925.03A2, which is the charge of trafficking in heroin, a 2nd degree felony carrying a mandatory prison term of between 2 and 8 years is set by the judge, a possible extension of up to 50%, a fine of $15,000, a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds that on this day in open court, the defendant was advised of all his constitutional right and made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal Rule 11. Pleas are accepted and ordered filed. Defendant's found guilty of counts 1 and 36 as alleged. The remaining counts are dismissed as to this defendant. As noted in the plea colloquy, these are mandatory, or count 36 is mandatory, and Mr. Howland is on post-release control for previous offenses, so the court will go ahead and proceed with sentencing forthwith. Mr. King, anything on behalf of the state?
Only was contained in the plea agreement, Your Honor.
Mr. Blosser?
Your Honor, I would also ask that the court follow the recommended sentence in the plea agreement. I would also, excuse me, additionally note that on September 19th, 2023, Mr. Howland had filed and filled out and filed a financial disclosure form indicating that he receives Social Security income. That was signed by Mr. Howland. At that point in time, we asked the court to determine that he is indigent in these circumstances, Your Honor. Thank you.
All right, Mr. Howland, anything that you would like to say?
No, not really, Your Honor. I just, I had an addiction of speaking. That's all I can say.
How old are you, Mr. Howland?
65.
Well, I know we've known each other for many, many years. And, you know, you've certainly had a long criminal history, and I'm sure that drugs have been part of it, and I understand, understand that, but, you know, sooner or later you're going to have to change, you're going to die. How many numbers have you had, Mr. Howland?
6.
6 numbers, okay.
I just put myself in rehab before I got locked up this time, Your Honor.
Okay.
Myself.
Well,
Too late, but I didn't.
well, you'll have some time to stay clean in prison. Hopefully you'll take advantage of that, and, you know, the treatment that they have that's available. So, as it's the order of the court that as to count 1, you be sentenced to a term of 4 years as a minimum, with the possibility that could be extended at the discretion of the Department of Rehabilitation Corrections by up to half of that term, which would be an additional 2 years, so it could be up to 6 years. With regard to case or count 36, you're also sentenced to a period of 4 years. That is mandatory, however, as required by the statute, so it cannot be, you have to serve every day. That under the law, that will be served before your other charges in count 1 is served. 2 offenses could be extended. So if they extend on count 1, they can't extend count 2. If they extend on count 2, they can't extend on count 1. So you only be subject to 1 2-year extension. Now, in addition to that, the court also sentenced you to serve the remaining part of your post-release control time, which is 833 days, and all 3 sentences were to be served consecutively to one another. Now, the court finds that consecutive sentences are necessary. First of all, they are stipulated to by the parties. Secondly, these offenses are committed as part of one or more series of conduct, and that the harm caused by the 2 offenses is such that one single sentence adequately reflect the seriousness of the harm caused to the public, and the sentences are not find that your previous criminal history, 6 prior numbers as you've indicated, is such that it's necessary for the protection of the public that consecutive sentences on counts 1 and 36 be imposed. Now, according to the sheriff, you were arrested, I guess, on both indictments on the same day. 168 is being dismissed. They did give all the credit to that case, but I'm going to give it to you in this case. So that's 40 days. September 12th was your arrest date, right?
Yes, sir.
All right, well, actually, it's more than that. 9 and 9/12 would be 18, and then 10/26 would be 44. I'm going to have to check their calculator out there. All right, so 44 days of credit. Now, upon completion of the prison term, Mr. Howland, and any extension, as well as your PRC case time, the Adult Parole Authority will put you under post-release control once you complete your sentence on the offenses for at least 18 months, up to a maximum of 3 years. And as you know, in the event that you commit a new felony during that period of time, then the judge in that case could sentence you for committing that offense while under post-release control in these cases to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. Also, if you commit a violation of the conditions of supervision, then the adult parole authority could return you to prison, make you serve a possible 9 months maximum for any single violation, up to a maximum or cap of half of the prison term for all violations. You're also ordered to pay the court costs, which judge of grant execution is ordered. If you fail to do that, then the court could order that to be collected by various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, the court can order you to do community service, and you'll be given credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by the amount until paid in full. Pursuant to the plea agreement, you're ordered to pay $360 in restitution to the task force, payable through the Huntington County Victim Witness escrow account, and you'll pay any service fees connected with that. The court will also find that because you are indigent, that there is no likelihood you're going to have the ability to pay